Good morning, everyone. Welcome back to another action-packed day here at the World Justice Forum. I hope you will all agree with me that last night's performance from the Afghan musicians, our Rule of Law Award winner, our dance troupe was really moving and inspiring and a reminder of how important the power of expression in this work we do, and we're here now to think about what works. Identifying what works is the theme of our day, and just to walk you very briefly through the program, we will start with a plenary discussion this morning on that theme, and you'll enjoy that conversation that will be led by our board member, John Neri. We will then break for our World Justice Challenge showcases. And please, if you have signed up for a showcase, go to that room. If you haven't, just pick one and go. We'll make room for you. There will be interpretation in those rooms in in 4 languages of the conference. So grab a headset if you need one. We will then, after the showcases, break for lunch and come back here at 1300 for a plenary hosted by Hill, the Hague Institute for Innovation of Law, on systemic reform and people-centered justice. Then we move off-site, and we're asking everyone to please move to the front of the building to get on buses that will take you to the off-sites. You must register for the off-sites before getting on the bus. If you're having trouble registering, go to the bus anyway, and we'll work out on-site. After the off-site sessions, we invite you to a reception at the Amare Performing Arts Center in downtown The Hague, and there will be buses from the reception back to the hotels at 6:30 and 7 o'clock from Amare to the hotels. However, we encourage you to please stick around and come to the film house where there will be 2 events. One is a documentary film presentation on criminal justice in Mexico, the other a jazz opera on Holocaust refugees. After the film house, people will be on their own to get back to their hotels, but we'll have folks on hand to assist you as much as possible through the tram system or taxis. Last note, for our partners and sponsors who are in the room, could you please join us for a group photo at 12 o'clock or shortly thereafter at the Cube, that landing area between the ground floor and the first floor, at the Cube at 12:05. I now invite John Neri to moderate our opening plenary. Thank you.
Good morning. My name is John Neri, and it is my honor to serve on the board of the World Justice Project. And it is my distinct privilege to serve as moderator of this morning's plenary session. Today is Pivot Day. We spent all day yesterday defining the challenges that confront rule of law communities around the world. Today we pivot to solutions. The question for the day is, what are the promising approaches? Where are the success stories? Who are in the virtuous circles that show that we can strengthen public integrity, improve and increase access to justice, counter all forms of discrimination? To answer that pivotal question, we have a very high-level, very distinguished panel of 5 experts. 4 of them are here with us in The Hague. A little later, it will be my happy task to introduce them to you. Our 5th expert is joining us through a recorded video statement. After we play the video, we will have time for, I think, 4 rounds of questions. I hope that the 4th set of questions will feature questions that you will post through our World Justice Forum app. and I will read them off the tablet that has been given to me. I think that we are all set. Let me introduce the video from the Chief Justice and President of the Supreme Court of Kenya, the Honorable Martha Koome.
Good morning, colleagues. Thank you for inviting me to speak to the topic, identifying what works, during this seminar on the World Justice Forum 2022. My name is Martha Koome. I'm the Chief Justice of the Republic of Kenya and the President of the Supreme Court. Sharing the Kenyan experiences, I would like to begin by stating that we are pursuing an agenda geared towards people-centered access to justice, which we call social transformation through access to justice. Our vision is geared towards attaining outcomes that will improve institutional performance and deepen access to justice for all, especially the vulnerable and the marginalized in our society. It ensures that access to justice is easy and cheap enough to be afforded by even resource-poor individuals or groups are able to bring their grievances to courts or tribunals. The global pandemic, COVID-19, has forced justice systems to adapt to and to continue delivering justice. To acclimatize to this changing context in the delivery of justice, the Kenyan judiciary has embraced new technologies to broaden access, to ensure there is data, evidence-driven decision-making. And we have introduced numerous novel avenues to resolve disputes tailored to culture, pauses, and social conveniences, while maintaining the impartiality and fairness that is required by us by the law. We are calling this the multi-door approach to the delivery of justice. For instance, we are actively promoting court-annexed mediation and alternative justice system as part and parcel of our menu of avenues for accessing justice. We have formulated and are implementing an alternative justice policy that promotes and integrates traditional justice systems as a key component of our system of delivery of justice. I will share with you the measures and strategies that we have adopted to ensure that we leave no one behind when it comes to the quest for justice. The pandemic and consequent social distancing rules enforced by the government in the year 2020 and 2021 forced us to intermittently suspend physical appearances in court so as to contain the spread of the COVID-19 virus. To mitigate the impact of reduced physical meetings, the Kenyan judiciary rapidly rolled out virtual courts and electronic filing of court pleadings, which was unprecedented practice, and whose benefits have gone far and outweighed the challenges that we were facing. At the same time, we adopted innovations and strategies to mitigate the potential of digital exclusion. These include the use of Huduma centers, the government's decentralized e-service centers, to facilitate access to internet for e-filing and virtual courts, including the Huduma Center, which is a government-run agency, will supplement the use of cyber cafes and mobile smartphones, which come with cost implications to the public. In addition, we have introduced interagency virtual booths or centers in prisons to enable remandees to attend court proceedings, and even those who are sentenced to present their appeals virtually with guaranteed access to computers and internet that have been availed to our prisons. We have also adopted a data-driven and evidence-based approach to decision-making. This includes having courts file daily returns on their work as a form of accountability and performance monitoring. This has enabled us to make sound administrative decisions, like the staffing of courts, transfer of judicial officers and judges, and also for us to address the issue of infrastructural requirements and technological requirements that is evidence-based. Another game-changing initiative that we are pursuing with respect to deepening access to justice is the rollout of the small claims courts. These courts are vested with the jurisdiction to determine cases that involves claims of less than 1 million Kenya shillings, which can be translated to 10,000 US dollars. Through a process that is characterized by procedural simplicity, efficiency, and expeditiousness in the delivery of decisions. Decisions from the small claims courts are rendered within 60 days. And this is really helping solve the problem of backlog and delay in the resolution of disputes. The small claims courts have ensured that a category of citizens, especially those in small, medium-sized businesses, startups, who previously did not have access to courts, now have an avenue for a peaceful resolution of their grievances, including persons who have suffered personal injuries. We have also taken steps to introduce special measures to ensure access to justice for the vulnerable groups. And in line with this goal, we established a special sexual and gender-based violence court with one pilot court which we have operationalized in Mombasa. We are in the process of rolling out these courts to all the regions in the country. The SGBV courts will ensure tailor-made judicial intervention that is sensitive to the unique circumstances of these crimes, and will ensure that there is expeditious disposal and especially the protection of the victims. As we renegotiate our justice system and its efficacy in the post-pandemic period, we are focused on ensuring that more people can access justice. In the next 5 years, we hope that more than 20 million Kenyans will have full access to justice without the perils that have plagued the justice ecosystem for years. We are also looking out to empowering Kenyans to know their rights and even to understand the pitfalls that bring them into conflicts with the law. I am looking forward to extending this conversation beyond the Kenyan judiciary to learn and share with others what works in this respect. I thank you very much for listening.
Thank you, Chief Justice Martha Koome. Now, I would like to call on the members of our very distinguished panel to come up on stage, starting with the Minister of Justice of the Republic of Uzbekistan, Minister Rusliban Daveltov. I would like to call on International Forensics Investigation Specialist Christoph Royan, the General Secretary of the International Trade Union Confederation, Sharon Burrow, and Justice Hatari Waweru of also the Judiciary of Kenya. Thank you. Maybe we can start with Justice Waweru. Maybe he can take off from the Chief Justice's recorded video statement. So I have the same question for all of you. We'll start with Justice Waweru. What were the strategies that were most successful in meeting the challenges of the rule of law communities?
Thank you. We have had quite a number of challenges. The first one that I can address is culture change. Enlisting genuine commitment from judges and judicial officers is critical for any program intending to perform in the judicial system. Although strengthening oversight and supervision to enforce reform initiatives is an important step, such actions will have little effect if judges and judicial officers refuse to embrace the reform initiatives. To ensure the reform initiatives work, the Kenya judiciary has mounted culture change programs that enable the judges and judicial officers to appreciate and embrace those changes that are being rolled out. This reduces opportunities for resistance and sabotage of the reform initiatives. In addition, tackling the problem of institutional culture also involves creating new capabilities within the institution. The recruitment process in the institutions emphasizes getting on board persons who are aligned with the new ethos and vision of the institution and thus can champion the new practices being institutionalized. There is also the need for constant consultations to secure support for the reform initiatives, an approach that is inclusive to build support for the reforms and also offer reassurance to those who might feel threatened by the reform initiatives. The Kenyan judiciary has embraced a consultative approach to get ideas of stakeholders on board before any reform initiative is implemented. There has also been a great need for leadership skills training programs. Leadership capacity is critical in driving change. Court stations in Kenya are headed by judges and judicial officers, depending on their seniority. It is noteworthy that previously, attainment of these leadership positions was not preceded with any leadership training. This has changed, and heads of stations and presiding judges regularly attend leadership training programs to equip them with the skills and competencies to drive change in the court stations. I think it is also worth mentioning that institutionalizing of court user committees is important. Court user committees comprise all actors in the judicial sector. They are usually based on the county. That is the administrative unit in our country, and there are 47 of them. For reforms to take root, users of the justice system, whether lawyers or everyday citizens, have to be part and parcel of the reform initiatives. In addition, court users need to demand that judicial officers deliver quality services. The institutionalization of court users committees opened lines of communication for citizens to register complaints, suggest changes, and receive responses on how their court stations should operate. Through this approach, court users have become critical supporters and drivers of the institutional reform initiatives and interventions. Thank you.
Thank you, Justice. Minister Daltoff, what have been the most successful initiatives in your area?
Thank you very much. Thank you for inviting me here. I think this event is very wonderful. For the last 5 years, Uzbekistan has been seeing sweeping and really systemic reforms in all parts of the public life. And if you ask me what prompted these reforms, I would say that the first is demand of the population and introduction of, easing of freedom of speech, and then the willingness of the public institutions to react to these demands. But the most important is, of course, the political will of the new leadership of Uzbekistan. So where we started from acknowledging openly the problems that we had, the forced labor, the ill treatment in prisons. Even the president in his official resolution acknowledged that there were problems with the inhuman treatment in prisons. That was a really brave step. So after that, we introduced many steps to open up the information, so access to information about public procurement, about expenditure on public construction, tax benefits on companies, privatization of state objects. And so we gave access 200 types of information in 33 directions, and 13,000 pieces of information were made available to the public. In 3 years, the position of Uzbekistan in open data inventory went up for 125 positions in just 3 years because of this new transparency regulations. Also, after that, the new administrative justice system has been introduced. Totally new courts have been set up, administrative courts with 150 new judges where people could sue the state agencies. And the society really welcomed this action. And they're already actively using their right to sue the state bodies. And for the 1 year, where the courts are considering more than 15,000 cases, and 52% of them, they're winning the case against the state. So this is a really good change in terms of access to justice and due process and rule of law. Also, when you have a system of government agencies, the Republican level always, they attain to the really high standards. But you have middle level and the district level. So most of the problems we have with the middle and low level of state agencies. So because of these new tools, the society started to discipline them, suing them. And in one year, 2,500 decisions of the local executives were abolished by the courts. So this is a really good example of how the society can make the state bodies work. And the third direction is bureaucracy and corruption. So we did a lot on cutting the red tape, digging into the administrative procedures, the corruption risks and administrative burden. So we got rid of more than 3,000 pieces of legislation. So we used the principles of regulatory guillotine. It's almost 10% of the whole legal framework of Uzbekistan. 3,000 legal acts were abolished. And also the licensing. Licensing system always attracts corruption and bureaucracy. So we got rid of 105 types of the licensing cases. That's almost 1/3 of all types of licenses that we have. And everything went electronic. Licensing is electronic. Land allotment is electronic because the executive used to have these powers and they were really arbitrary decisions, just giving the land to the people that give money. So now that's not possible physically because this is all electronic auctioning, and already 5,000 land plots were already selling, and lots of money, billions, millions of dollars are pouring into the budget. And talking about bureaucracy, we got rid of 18 types, only 18 types of the documents that people needed to submit to the government agencies when applying for public services. It led to economy of at least $15 million, and it touched the lives of at least 12 million population of Uzbekistan. Just 18 types of documents, because this bureaucracy is, from the Soviet times, nobody did the business process re-engineering. So if you do these kind of things, it really changed the quality of life of people. But I would say that's not the end, because we have lots of more problems, and society is demanding. The expectations are higher than sometimes the government agencies can deliver. But we're working on this. We know our problems and moving forward. Thank you.
Thank you, Minister.
Thank you.
Sharon, you run one of the largest organizations in the world, the International Trade Union Confederation. From your perspective, what are the success stories that you can point to?
Well, I'm delighted to follow the minister because I have a soft spot for Uzbekistan. Because when I started this role about 11 years ago, Uzbekistan was riddled with forced labor. But the minister's right, child labor and indeed forced labor. The minister's right, they decided to do something about it. And the rule of law, like in any circumstance, is effectively what works, the rule of law and compliance. So for working people, if you think about this as the social contract backed by the rule of law, that's the most effective strategy. But we're now facing a convergence of crises where we need to go back to the basics in terms of the rule of law and to add new laws to deal with the current economy and what is effectively a broken labour market. If you think that the International Labour Office meeting right now was in fact established just over 100 years ago out of the ashes of World War I, and our founding fathers of that institution, sadly no women, but there are women today, then in fact they knew that you needed a global rule of law to create a stable labour market, but also to build just communities where common security would be a preventative for war. Come 100 years forward, we have in fact a broken labour market. 60% of our workers are working informally. No minimum wage, no social protection, no rule of law at all, no rights. But 40% even, a third of those are now in insecure or precarious work, and our new platform businesses or internet mediated work is in informal business, often without the rule of law. So we need to look again to what will it take to regulate the labour market. Now, we've had some successes. If you think about the growth in domestic and workplace violence, particularly gendered violence, then fighting for 10 years for a convention, Convention C190 of the ILO, has resulted in a convention that is not just now being ratified, but you're seeing advances on the rule of law. I'm proud to say in my own country, Australia, just last week with a shift in the elections, the unions had fought for 10 days of domestic violence leave. Canada also a front runner on this. And the new government promised to extend that not just to the 30% of award workers who won the case, but in fact to all women. That's victory because it becomes the rule of law. We're seeing adventurous law around areas like remote work or teleworking. We're seeing, particularly in Spain and Argentina, we're actually demanding a new social contract that in the right space will have mandated due diligence, not just fundamental rights laid down by the ILO for everybody, but indeed the mandated due diligence, first of all a treaty, a UN treaty, around the UN guiding principles for business and human rights. But now a law in France, a law in Germany that mandates corporations to do their due diligence, to look at their risk profile, but also to put in place grievance and indeed grievance procedures for remedy. We're also looking at expanding how you take grievance procedures by agreement with companies to The Hague, to here, with the Court of Arbitration. So in the end, there are many strategies that work, but if we don't rebuild the social contract, jobs, jobs and jobs, full employment, and that means formalising informal work as well, and we have a target for 2030 to return to full employment with formalising 1 billion informal jobs. But on the rights front, if we don't return to the fundamental basis of rights in everything we do, including global trade, then you can't establish just communities or fair competition floors. But we want equally equality in that, equality of income, of gender, of race. If we don't build an inclusive future, then who will? And it's exactly as the Minister said, communities need to demand this. Let me leave you with one strategy that we think is overwhelmingly going to be successful this week. Occupational health and safety will be added at the ILO to the fundamental list of rights, which are freedom of association, to join, of course, a trade union, to organise, to bargain collectively, to be free of discrimination, forced and child labour, and we hope, as of the weekend, occupational health and safety, because if COVID-19 taught us anything, it's that people must be safe. And when workplaces are safe, there are also safety, preventative safety measures for the public. So, rule of law, compliance, we have to make sure that with the anti-corruption measures that the Justice talked about are in place and they're adhered to.
Thank you. That is very good news. Christoph, you work with both private and public sector organizations. Your reflections on what works?
Yeah, saying what works in asset tracing, asset recovery, I would say I come at this at a slight disadvantage. Because obviously the fact that this is even needed, even if it works very well, the main reason it is needed is that something else clearly didn't work in the first place. So it's a bit like, say, emergency dental surgery. Even if it's very well done, you really wish you didn't have to do it in the first place. So, having said that, I personally think that the whole topic of asset tracing and asset recovery, when we're talking about government corruption, is, well, I wouldn't go so far as to say it's a central element of a successful anti-corruption strategy, but I think it is an important element for two reasons. One, fundamentally, it's good for society to get the money back. And I'll be very honest here, when I have discussions with clients in the public sector, I tend to be very blunt about it. I always go, I'm not in the justice business, I'm in the getting money back business. These two may overlap, ideally they do. I'm very pleased if they do, because it gives us a good feeling. But the question is, what is it that you want? And I'm coming to that in a minute, what that means from a practical point of view. And the second thing is, it ultimately sends a very, very important message. In the grand scheme of a national economy, no matter how much you recover, I mean, okay, there are a couple of examples where it's slightly different. Philippines would be one, Peru would be another, and I'm using the Peruvian example in a minute for something else. Fundamentally, the money probably doesn't even matter that much, but it sends a very important message that people who stole from their own society shouldn't be able to keep it just because they managed to get it overseas. And I think that adds to the credibility at a political and at a social level. So that's why I think it's important to pursue this. Now, if you're looking at the success factors here, there is a probably unfortunately titled, because the title was actually few and far between document from the Stolen Asset Recovery Initiatives that came out in 2014. And they identify 4 success factors that I think are still crucial, and I will relate to 3 of them here because I don't really deal with the 4th one. That is top-level commitment to asset recovery. You need to want this and you need to agree that you want it. A wide range of tools, flexibility in how you do it, and proactive as in looking at this from an end game scenario. The 4th aspect they highlighted was the role of development agencies, but I don't really work with these guys, so I'd skip that one. But if you can get these 3 things in place, if you can get the total commitment, if you have flexibility on tools, and that's the point why I say I'm in the getting money back business. One of the questions I always ask my clients here is, how important is it that everybody who is guilty is actually convicted? Clients generally go, oh, we think this is very important. And I go, okay, fine, fair enough. How much of that would we be happy to let go if that increases our chances of getting the money back? Do you aim for 100% criminal responsibility, or do you go, you know what, let's go for civil recovery? That may have a better chance of getting us the funds back from overseas, from the places where they're usually stashed. It just means that maybe some people go free where you say, okay, I'd really prefer to lock them up. And so that my experience with successful asset recovery is that the things work best where you actually play with these factors, where you look at them in a very dispassionate way, and to some extent that's my role then in those discussions, as I really don't have a stake in the game, I don't work on a commission basis. I'm just saying, okay, this is your range of options, I appreciate you would want all of them, but if we have to prioritize, where are we going with this? And these are the things where you actually stand a good chance of getting the stuff back, and also, most importantly, speeding things up a little, because as we all know, international asset recovery can take forever.
Thank you. You know, we were supposed to have a second round of follow-up questions, but we're running long. If you don't mind, I just want to ask one follow-up question of the minister who spoke of the regulatory guillotine. I'm curious to know, Minister, which of the initiatives that you highlighted was the most difficult to pull off? Maybe it's the same thing as asking you what was the most satisfying success story that you can share with us. But I wanted to know about the difficulty being overcome.
Thank you. That's a very important question because, you know, you have ideas. Some people in the government have ideas. They want to implement them and make life better. But we have the other part of the government who are working for ages in an old manner. Then it's the problem to get through these old, you know, bureaucratic barriers. That is the quality of civil service is at the heart, because the government is responsible for everything that is happening in the society. It's not the people who blame, you have to blame the government. That's why it was very difficult for us to build a team, because our new president, of course, his political will, and he built a team, and we came around. Many people came back from other states. So expats came back. He was calling for everybody to come back and join him. So there was a critical mass of people who were directly working with the president and getting the ideas to him. So that is very difficult part of this.
Thank you.
Can I just
Yes.
say,
Yes, please.
it's such a success story. Uzbekistan is an incredible success story for eradication in our world of forced labor, ratifying Convention 87, 98, freedom of unions. You know, I'm hoping in December that I can actually announce to your government that Uzbekistan unions have become a full member. But the story for women in Uzbekistan and the law surrounding the rights of women is also inspirational. And your Minister Tanzila is someone I dearly love. You know, just the force of commitment in that country shows you what you can do when people work together, governments, but also organisations in the society. So congratulations.
Thank you. Thank you very much.
Thank you.
And about the success that you asked.
Yes, please.
So I want to give an example of one particular measure that we implemented about the decisions of the local executives. We made this online, so nobody would use any paper. Initiating, you know, consulting with other experts, everything went electronic. So for the last 1 year that we introduced this, 170,000 decisions were made, and they all went online. And imagine the use of public money, you know, for different purposes, so people could see this, even if you can, you know, access any decision and you see where the money is going. And it caused a public condemnation about many, many decisions, and thousands of the decisions were repealed by their own, you know, by the local executives. And it made us economy 1,700,000 pieces of paper. So it's almost 10 tons of paper. Just one measure. So I recommend this. Thank you.
Thank you. We have about 8 minutes left in this particular round of questions. Let's widen the scope of the discussion. Let's talk about replicating or scaling the success stories that you've pointed to. Justice Waweru, the Chief Justice mentioned bringing the changes that she talked about, in her words, beyond the judiciary. How do the judges of Kenya propose to do that?
I think the most important thing is committed leadership to begin with, obviously led by the topmost person. Our context here is, in the year 2010, the people of Kenya renegotiated their social contract, which resulted in a new constitution. The first Chief Justice appointed under that new constitution, Dr. Willie Mutunga, came up with a very comprehensive judicial transformation framework intended to turn around the culture of the judiciary, bring justice closer to the people, and completely change the way things were done. After him, there was Chief Justice David Maraga, who followed that up with sustaining judicial transformation. And now we have Chief Justice Martha Koome, who has come up with social transformation through access to justice. So unless you train people in new ways, unless you get them to commit to the new ways, unless you sell the idea to them that this is the best way of doing things, then you will fail. So we have many, many training programs for judicial officers, for judges, for administrators of the courts going on throughout the year, aimed specifically at realigning, as it were, the mindsets of all the actors concerned. Along with that, of course, there must be cooperation with the other justice actors, through our court users committees. These are the police, these are the prosecutors, Office of the Director of Public Prosecutions, and other actors, and of course the prisons that reform the people that we take to them. So it has to be a concerted effort involving everyone concerned, and that is where we are. Thank you.
Thank you. Having the right people in place, having committed leadership, is a necessary condition of change. But Sharon, as the minister said earlier, there's a need for sweeping and systemic changes as well. When you talk of the need to rebuild the social contract, I mean, you're not just talking about having the right labor leaders in place, right? I mean, what else do we need?
No, we need a whole of government at all levels approach with civil society, with trade unions, and with the rule of law. So if you look at what the UN Secretary General has promoted, he's having a summit in 2025 for a common agenda. And he's put the social contract at the heart of that. He's actually established right now a global accelerator for jobs and social protection, because universal social protection, protected by law, is the resilience base for the convergence of crisis we all find ourselves in, from the current cost of living in crisis with inflationary spikes to the social protection necessary when the economy's collapsed or sections of it collapsed with COVID, to indeed historic levels of inequality. And climate change. If you're going to have just transition for climate transition, and we all have to deal with the climate change demands, then you have to have those things in place. And now he has a commission that will report in January on effective multilateralism. And again, he's put the social contract at the heart of that. So what does it mean for workers? It means jobs, jobs and jobs, climate-friendly jobs with just transition, but it means rights, and it means to go beyond just the rule of law, to build those labour courts. Sometimes, because of corruption, we're building alternate dispute resolution mechanisms with governments and employers. And indeed, while we can actually look at court reform, but the rule of law is critical. But it needs also corporate compliance, and that's why we're looking at mandated due diligence. But it requires social protection, equality, and inclusion. Because if you look at the world now, we have a crisis with refugees. By 2050, with climate change, we could have 1 billion refugees in the world. So we have to go back to those areas of what does it take to put people and planet at the heart of the way we build our legal systems. And I would finish with one example that says, you know, 11 years ago, we took on a fight around forced labour with the state of Qatar. I was probably their worst enemy for 5 or 6 years. But using the ILO complaint system, the rule of law, and being willing to negotiate, we've now changed the laws in Qatar. We helped them build labour courts. The government themselves has built remedy funds. So it's possible if you have the elements the minister talked about, the demand from people, whether it's civil society or citizens or other groups, and indeed the capacity to negotiate and monitor justice with an end to corruption. It's something we've all got to be committed to.
Thank you. Let me start asking questions from the audience. For Christoph, what strategies from successful asset recovery in the private sector could be used by government actors or the judicial sector?
This may come as a surprise, but actually in my experience, it's rather the other way around. If you give me the choice of working for a government or working for a private entity, I'd always go with the government. Why? Because you have a lot more options at your disposal as to what they can do. And I give you an extreme example. I didn't work on that. I can't talk about clients, but when Peru went after the overseas assets of the former de facto head of intelligence, Vladimiro Montesinos, following the Fujimori government, they actually went so far as part of the process to make change, to introduce legislation that would allow for plea bargaining, which I understand wasn't really a part of Peruvian law beforehand. Now, I'm not saying that every time you're doing serious asset recovery, you should change your legal processes. It's probably not a good idea either. But that's the kind of capability that a state has. When I work in the private environment, say somebody stole a lot of money, there are two factors there. First of all, there are very, very few cases in the private sector where the money stolen is so massive that it's difficult to hide. We're usually not talking super yacht, private jet territory. So this is stuff that can still go through the regular banking system, and I don't really have that many ways of getting information. If this is government corruption, if the government's behind it, if you have serious commitments, you can tap into intelligence, you can tap into law enforcement, you can look at these various angles, you can talk to regulators, you can talk to banks. It's a completely different drive. Actually, the lessons learned is moving more in that direction.
Thank you. The next question from the audience is for both the Minister and the Justice. When introducing electronic mechanisms and making licensing completely digital, something that the Chief Justice also mentioned in her video statement, how do you ensure that it reaches the population that has limited access or no access at all to the internet? First?
Okay, that's very good questions. We introduced one-stop shops around the country. It's like 207 centers around Republic and more than 150 their subsidiaries. So you can go there, and then you have free access to internet there, and they have the people who explain you and help you with that. But when we talk about the business organizations, they know how to use the internet, they have direct access, because in our times, if you are not having internet, you are not a business organization. So that's a compulsory for business organizations. But for people, it's not compulsory. But, I mean, not compulsory because you have to come to the public service center and then do it online in any way. You can't file it on paper.
Thank you.
That's the way out.
And,
Yes.
and Justice,
I like
the
this.
Kenyan judiciary went digital as a pandemic response.
Yes, the Chief Justice mentioned Huduma centers. Huduma centers are centers established by government to enable the citizenry to access services through the internet at no charge at all. So we have lapped onto that service in order to enable the citizens to access their cases and other services of the judiciary through them. Now, in addition to that, all court stations have customer care desks, which have computers, and through them, anyone will be able to get information that they may need regarding any of their cases or any other service that they might need. That is how we are trying to facilitate e-services in the judiciary.
Thank you.
And can I say for
Yes,
working people, if you're a migrant worker going to another country at the sponsorship of an employer, then what's working is where there are transparent systems of contract. They're registered online by the government, the worker has a copy, the employer has a copy, and indeed the courts, the labour courts can access those contracts for any breach or alleged breach of contract. And then, of course, the transparency of a time-bound solution in a labour court is working. So digitalisation has some pitfalls, but it also has some solutions for us. And I would say one of the things we're fighting for in your area is, along with the tax laws, is beneficial ownership registry, where you can see which companies, who owns the shell companies and the various tiers of companies, which might make it just a little easier. But we all need to say what's the use for digitalisation, that benefits people and justice, rather than when it's used for surveillance and intrusion and more ugly or nefarious reasons.
All right. Time check. It's almost 10, but we started our session at 9:10. If it's all right with you, I'd like to borrow a few minutes from the coffee break so we can continue with some of the questions. The next question is for the Minister and for Sharon. Progress breeds higher expectations in the public, but rule of law change comes slowly. So how do we make sure disappointed expectations don't lead to a populist backlash against reform? This is a little late for me in my country, maybe 6 years late, but I would like to know your thoughts on this.
Yes, that's very hot topic back in my country, because as you say, when you give the possibilities and new easing of life, and the expectations will rise faster than the public institutions can deliver. That's for sure, because parallelly you have the freedom of expression, which is also rising, and you have the power of the social media, where everybody can give their ideas, and it goes viral. It depends on the topic. So what we do is we try to explain the pace of the reforms, and we give what steps would take and when we're going to take those steps. Even in justice sector, for instance, 4 years ago, we didn't almost have any decisions by the courts when people, it was like 100% you will get the conviction. 100%. Now we have thousands of decisions when they free the people from the courtroom. But people are now demanding more. They're saying, we need an access to the court proceedings. We need video recording. So we are giving these opportunities. They want online transmission of the court cases. So we are also moving forward to this. Again, Sharon, you're saying the demand of the public is rising, and we're doing our best to meet those requirements. But I don't think that no state can meet the demands of the people. There's always a problem, there are always challenges, but the main thing is dialogue. It's direct dialogue of the ministers, of governors, even the president directly talks to people and explains what the plans are and how we're going to do them.
Thank you. Sharon, you run years-long campaigns. How do you sustain both the momentum and the enthusiasm?
Well, those three elements are critical to any campaign or any solution: commitment, dialogue, and communication. And but in fact, we take a view that anyone who thinks you can win a change of attitude or indeed the rule of law with a poster or a sticker or a demand is simply not going to work. So if it's not a 10-year strategy, you're not going to win. Now, you can win with inside 10 years, but if you don't have a 10-year outlook and you're not making it clear to people that there will be steps along the way and you'll have to fight, you often get 2 steps forward. If it's a government, they change the government, or indeed if it's a judiciary, sometimes they retire. But if it's an employer, the same thing. The life of a CEO is often 5 years. Well, is 5 years on average. So you have to actually plan your strategy very carefully and just make sure you have focus. If you really want to win something, just don't give up. It's that simple. But it can be both an outsider and an insider story. I've never believed you can win anything as a trade union activist if you've not got people behind you, and indeed if you haven't got somewhere to settle it, whether it's through dialogue or whether it's through the rule of law. But changing laws does take time. But in the end, it's the thing that actually makes sure that compliance is sustainable.
Thank you. For the final question, I'll give you 30 seconds each, if you don't mind, starting with Justice Oweru, and then Sharon, and then Christoph, and ending with Minister Davutov. If you could recommend one thing that will change the game, so to speak, and that will benefit rule of law communities around the world, what would it be?
For us, it is the small claims court. Take justice to the people. Let their cases be determined as soon as possible with as little procedural impediment as possible. Thank you.
Thank you. Sharon?
Just one.
Just one.
I think, you know, labour courts everywhere that are free from corruption, that are time-bound in their decision-making and are transparent with digital tools so people can, in fact, feel confidence they can get, a little bit like the small claims issue. Speedy access and remedy is essential.
Thank you. Christoph?
Hard one. Probably, I would say, address the whole question of asset tracing, asset recovery from a results point of view, as in show flexibility, leverage the private sector, look at different angles, look at what will actually get you the result, rather than start from a dogma and hope that this will also result in some recovery.
Thank you. And Minister?
My recommendation is to stick by universal values and rules, because some states, they cite their uniqueness and peculiarities. We have different historical background, religious background, but everybody knows that already the social contract, Hobbesian social contract, everybody knows that, they are known. Weberian state principles, they are known. Universal values are already formed. So don't cite the uniqueness of your country and stick by the universal values, because everywhere, rule of law is transparency, independence of justice, anti-corruption, anti-bureaucracy, it works very well at the same level.
Thank you. Just a couple of reflections, quick ones. As a journalist of almost 3 decades, I have to say that I think most journalists are good at reporting problems, the challenges that we face, but not as good when it comes to reporting solutions, success stories. We need to have our own culture change in our profession. And secondly, to build more just communities, as Sharon pointed out, as everyone pointed out, we need a whole society approach. It's not just journalists, it's not just the government, it's not just society itself, it's everyone pulling together in the same direction. And on that note, I would like to thank Mr. Daviltov, Christoph, Sharon, and Justice Waweru. Thank you and good morning.
Thank you.